Caitlin, obviously, a very significant headline that you are breaking. What more can you tell us?
Yeah, this is incredibly significant. And of course, we should note that when the former president confirmed that, yes, this raid did happen on his Mar-a-Lago resort in Palm Beach, he did not specify why exactly this raid happened. So we are still trying to confirm that. Of course, I know you mentioned the missing documents from the National Archives and the concerns about that. So that remains to be seen.
August 8, 2022, FBI agents execute a search warrant at Mar-a-Lago. They find 102 classified documents. Some are in office desks. This isn't where the story starts. This is where the machinery finally breaks through. The law that matters forget, classified. The critical term is national defense information. It's from the Espionage Act, 18 U.S.C., paragraph 793E. The government doesn't need to prove espionage. They need to prove three things. Information relating to national defense was held without authorization. The person knew they had it, and they had reason to know disclosure could harm the United States. The law runs on notice, not whether you once had access. When you were told to stop. January 20th, 2021. The clock starts. The presidency ends. Under the Presidential Records Act, presidential records aren't personal property. They transfer to the National Archives, not a courtesy. A legal handoff designed to prevent one outcome: sensitive state material becoming private leverage. The archives pursue missing records for months. Nearly a year passes. Then, January 17th, 2022, 15 boxes are finally returned. Inside, 197 documents with classification markings. That's not a headline number. That's inventory from the charging document. First ratchet. Notice once Archives discovers classified markings, they must notify the Department of Justice. Administrative retrieval becomes criminal exposure analysis. Every communication from this point forward is potential evidence. You can misunderstand informal norms. You cannot misunderstand a subpoena. June 2022, the subpoena. Mid-2022, prosecutors get a grand jury subpoena for remaining documents with classification markings. Subpoenas don't ask, they compel. They also create a trap. Satisfy the demand partially while representing its complete, and you've created an obstruction theory. The subpoena is served. Documents are produced. A certification is provided. A diligent search was conducted. All responsive documents returned. If that certification is false, it doesn't just fail to protect. It becomes evidence. A statement the system relied on that evidence later contradicted. Second ratchet, certification notice, then certification. The escape routes appear here. Route 1, delay, negotiations, extensions, scheduling conflicts, procedural objections. Route 2, technical defense, arguments about presidential authority, declassification, what markings mean. Route 3, privilege, attorney-client claims, executive privilege, disputes over search scope. These routes are familiar. They're also limited. Delay buys time until a judge demands action. Technical defenses confuse until a jury hears the simplest question. After you were told to return it, why was it still there? Privilege slows testimony but cannot erase physical documents. By summer 2022, the government moves from trust to verification. Surveillance footage, witness interviews, testing whether compliance representations match reality. August 8, 2022, the search agents execute the warrant. Storage room, office areas, 102 classified documents seized, some in office desks. This isn't overreaction. This is the system concluding paper demands failed. When a warrant executes, the government doesn't take your word for what's in a box. It takes the box. Photographs, logs, seals. Writes it down to replay in court by someone who's never met the subject. Paper becomes physical enforcement. Third ratchet, contradiction. The case is now about three things: the subpoena, the certification, the search results. If the search finds documents that should have been produced under the subpoena, prosecutors don't need a complicated story. The documents are a silent witness that the prior representation was incomplete. June 2023, the indictment. Department of Justice unseals an indictment. Multiple counts of willful retention of national defense information, obstruction-related conduct. The indictment structure is a retention mechanism. It converts a broad narrative into countable events. One document, one location, one act of concealment, one date. 31 counts, 31 separate allegations, each tied to a specific document. This design prevents the defense from treating the case as vague misunderstanding. 31 is not a vibe. It's an accusation repeated 31 times. The Bedminster recording 2021. Bedminster, New Jersey. An audio recording captures the subject discussing a document described as sensitive. Major outlets report that on this tape, the subject acknowledged the document was secret and that he could not declassify it in that moment. Not the tone. The knowledge state. Awareness that the document retained its protected character. A recorded admission shortcuts the defense of ignorance. It narrows what the jury needs to infer. If someone says out loud a document is secret, then later claims that kind of document was never treated as secret, the jury doesn't guess at intent. The jury compares sentences. The tape establishes knowing the difference between having authority and not having authority. Now, I can't is a time marker. It concedes a change in status. That aligns with the core legal question. What happened after January 20th, 2021? Classification labels. Explained top secret. Category of potential damage if disclosed. No foreign. Distribution restriction. No foreign nationals should see the material. Highly sensitive documents typically require secure environments, sign-out controls, restricted facilities. But the legal case doesn't require jurors to become national security experts. 2 concrete principles. 1. Storage and safeguarding rules exist because compromise is banal. It happens through visitors, cleaners, unsecured rooms, copied keys, personal devices, opportunistic photography. Federal rules emphasize approved containers and controlled access. 2. Once notice is given, retention becomes willful if it continues. The financial escalation. Every timeline stage carries a cost curve. Compliance, internal searches, staffing, records audits. Defense, legal teams, motion practice, expert consultants, political finance, donors funding legal defense, committees collecting, opportunity cost. Time in deposition prep is time not spent in business or campaigning. The numbers that matter aren't only documents, they're deadlines. Each deadline forces a choice: comply, fight, or attempt a middle path that can later be construed as concealment. Why escape routes fail? The declassification argument sounds absolute. But the retention statute doesn't require formal classification to qualify as national defense information. The government points to conduct after leaving office, when presidential authority ended, and to lack of formal process evidence. The privilege argument can delay discovery, but privilege doesn't attach to documents themselves if obtained lawfully. Privilege fights focus on testimony, not the existence of material in unauthorized custody. Delay is the oldest route. It creates the most dangerous record. Every delay generates more communications, more representations, more chances for inconsistency. The architecture of evidence asset 1. The boxes. 15 boxes, January 2022, containing 197 documents with classification markings. First, physical proof records were removed and retained. Asset 2. The subpoena. The moment failure becomes willful. The baseline for obstruction analysis. Asset 3, the certification, a signed statement about search completeness, an evidentiary object, a single page that can outweigh 1,000 speeches. Asset 4, surveillance footage and witness testimony, shows movement, concealment, control. Asset 5, August 2022 search results, 102 classified documents seized, contradiction materialized. Asset 6, the audio, not a document in a box, intent stored in sound. Each asset has a corresponding vulnerability. Boxes create baseline possession, subpoenas create notice, certifications create reliance and potential falsity, footage creates corroboration, the story isn't invented after the fact, search results create contradiction, audio creates knowledge. This is architecture built to survive the one thing high-profile defendants rely on: ambiguity, systemic implications. If government accepts informal assurances after a subpoena, it teaches partial compliance is safe. If it enforces with warrants, it teaches representation isn't enough. Rules aren't optional because the custodian is famous or elections are approaching. Otherwise, it's not a system. It's negotiation between status and consequence. Forward pressure. 3 things to watch. 1. What evidence jurors will see and hear. Admissibility of recordings changes everything in document cases. 2. Scheduling orders. A trial date collapses delay strategies. 3. Scope of testimony. Privilege disputes and cooperation agreements shift cases without new documents. The nature of cost isn't punishment, it's friction. High-stakes defense consumes money because it consumes time. time because attention. Attention because the system requires answers, not posture. The system doesn't tire. The pattern. Strongest cases don't sound dramatic. They sound repetitive. Demand, refusal, demand, partial compliance, certification, contradiction, warrant, inventory, indictment. The remaining questions are narrower. That's what makes them dangerous. Which evidence survives pretrial motions? Which witnesses testify? Which deadlines are missed? Don't watch speeches. Watch the docket. If you were a juror, which matters more? A claim of right or a timeline showing you were told to return it and didn't? July 15th. 2024. The dismissal, Fort Pierce, Florida. Case dismissed on a constitutional theory about the special counsel's appointment. The machinery pauses. Government appeals. Months of limbo where everything is live and nothing moves. November 2024. The institutional ceiling. The Justice Department has a long-standing policy against prosecuting a sitting president. Once the subject returns to office, the prosecution's appeal is withdrawn. The appellate court dismisses it. The case ends not with a verdict, but with a jurisdictional and institutional